Tom, more gun laws update. It seems like every couple of months something else going on. Supreme Court is making some more decisions, helping us or hurting us. How are things going?
Well, it's a little bit of a mixed bag. Well, let's start talking about with the Rahimi decision. So the Rahimi decision deals with a guy, and just...
Not the best guy in the world.
You're not gonna like this guy.
Yeah.
I'm not asking you to like this guy. I don't like this guy. But nonetheless, he's the guy fighting for Second Amendment rights here. Not by choice, but because that's what he's doing. So, bad guy. He's in the fact pattern, he's shooting people up, he's being physically violent towards women. So he winds up getting a domestic violence restraining order against him, so an injunction. And as most of you probably know, if you have one of those against you, it is illegal for you to possess firearms. Okay. Except what did he do? He possessed a firearm.
Not only possessed,
yeah,
was shooting it off around town and waving it at people and all kinds of stuff.
It's amazing that gun laws never seem to work against bad guys.
Right.
But
they don't.
You know, we're going to skip that lesson because no one really ever learns that. We're just going to kind of press on with the case, okay? So he winds up being caught in possession of a firearm, winds up being charged, and is convicted and appeals it on the grounds that, look, the recent June of 2022, the Bruen decision, B-R-U-E-N, the Bruen decision, massive Supreme Court decision from 2022, basically says that a firearm law starts off as being up to the government to justify and to prove that it fits within the nation's tradition of historical firearm laws. And if it doesn't fit inside that tradition, there's a really good chance it's probably unconstitutional. Yeah, that's the low resolution take. If you want to go through the 100+ pages, I'm sure, you know, another video, right?
Yeah, absolutely.
But that's the very low resolution take on it. Okay, so Rahimi basically says, look, show me the historical tradition. And usually when we say that, we're talking about at least back to the 1800s and before, okay? And if you're pro-Second Amendment, you're arguing for the early Republic era, so you're generally talking 1830s and back. The people who are more pro-gun control tend to be arguing for Reconstruction period, 1860s, 1870s, and the reason being is that's when the 14th Amendment came in, yada, yada, yada. No matter how you cut it, there's no such thing as the domestic abuse injunction back then.
Right.
So his argument is, look, it's not part of the nation's historical tradition. Fair enough. The question, of course, is what will the Supreme Court do? Well, what the Supreme Court did, unfortunately, as I was worried about, is we've got some problems. If you're pro-firearm, we've got some problems. The Supreme Court basically found that this is lawful, and they compared it to the historical surety laws. Now, if you're like most people, you're probably saying, what the heck is a historical surety law?
I was just about to say that myself.
So the gist to the surety laws is if you've got someone who's just kind of a ne'er-do-well, right? They're just that person. What they used to do, when we're talking colonial times, 1800s, that kind of stuff, right, is you would not go to jail, you may not be charged with a crime, but you're going to post some money as a surety that you're going to be a good boy or girl, and if you violate it, guess what? Money gone.
Okay.
And it's basically the premise that we can establish conditions outside the premise of a criminal conviction. We can establish some conditions for you to continue to be out and about in society. Okay. Again, this is the low resolution take, but we're on point here. And they basically say this, look, these surety laws, this operates on much of a similar legal framework and grounds as these domestic abuse injunctions and more or less injunctions writ large. The way they wrote the decision, it really opens the door for, guess what? Extreme risk protection orders, i.e. red flag laws.
Right. And as I went through and looked at some of the things that Rahimi did, or is accused of doing, I guess allegedly did, some of them he was convicted for. You're looking at that and people are saying, oh yeah, maybe there's no way this guy should have a gun. This guy, you know, some of the stuff that he did rose to, and terrible, and rose to felony level stuff and things like that. And all I kept thinking about this case was, why did it have to be this guy? Right. Who's the person who's bringing this case about the Second Amendment is, why did it have to be this guy? And that's precisely why, is because people are looking at it and going, we don't want a guy like that doing stuff like this. And it's kind of like you said, troublesome for the rest of the Second Amendment community.
Well, let's take this one level deeper, because you're asking a great question of why did it have to be this guy? Okay, as a defense attorney and as an ex-state prosecutor, I can try to answer this for you. So if I'm a prosecutor, right, and I want to generally have the laws upheld, right, if there's someone who we are really worried about as, boy, this is like Mr. Squeaky Clean, he's contesting this law, it's kind of a weak case, he's got an amazing background, you know what, I don't want to make bad case law. So sometimes what the government will do is they will deliberately basically drop the charge or punt because they do not want that particular case going up on appeal to be the one to make the bad case law for them, okay?
Right.
So there's a coordination and there's an effort and a view for the long game that you can find sometimes with prosecutors, with attorney generals and so on, where maybe they're less interested in the conviction in this case and they're more interested in the X number of convictions that they know will be coming down the road downstream of this. So you gotta understand, on the one hand, the government thinks like this. On the other hand, okay, I've had many conversations with Mr. Squeaky Clean, who's got some sort of issue on their record. It could be untrue, it could be exaggerated, it could be maybe just a bad day, whatever the case might be. But when I have that conversation with them of, look, we need to talk about what you appealing this is going to look like, because you are going to become the face of domestic violence in your state and possibly the nation, depending upon how far this case goes. Do you know what this is going to do to your family, your career, your reputation? Because everybody's going to be painting you however it is that suits them, and a lot of people are going to be doing that to destroy you. And understandably, you get squeaky clean people who usually have built something of their lives, their profession, you name it, and they almost always step back and they say, you know what, that's not worth it. Now, you get Mr. Dangerous and crazy and reckless and in and out of jail and all that kind of stuff, Rahimi.
Yeah, he's like, I'm gonna try it.
He's got nothing to lose.
Right.
So between, on the one hand, you've got the government trying to look at the long game, combined with Mr. Squeaky Clean saying, I don't want to be the face of this. So who's going to be the face of something like this? Surprise, surprise, it's Rahimi. And surprise, surprise, bad facts make bad law, and here we are.
Yeah, and it's one of those things, like you said, it opens the door to the defense of extreme risk protection orders, which we don't like because they can be misused. And yeah, this is just a mess all around from top to bottom.
There's one more thing I don't like about it. There's a lot of things I don't like about it. There's one thing I want to alert the viewers to, which is the fact that, so in June of 2022, we had this Brune decision that laid out this constitutional framework for how we are supposed to challenge and attack gun laws to determine whether or not they're strike or ball, whether or not they are constitutional or unconstitutional, right? This is the first time we have seen the United States Supreme Court apply their own test, okay? I mean, in any big way downstream of that decision, okay? We've seen other courts, we've seen federal courts, we've seen state courts, but we've never seen the US Supreme Court roll through after Brune and say, this is how you do it. My concern is they were not exactly super close to the strike zone of what I would have wanted to see in order to protect the Second Amendment. In other words, I want to see something that is as close as possible, and they were very clear. A historical example does not need to be a historical twin. It can be an analog. In other words, it can be very similar, right? But a surety law and a domestic violence injunction, look, I get it. We're speaking the same language, but this isn't the same room in my mind. And my concern is they've arguably built a lot of elasticity into this.
Okay, so that's Rahimi. What's the next one we need to talk about from the Supreme Court?
Garland versus Cargill, okay? This is the bump stock case. Now, even if you don't own a bump stock, even if you don't care about bump stocks, even if you don't own a machine gun and you don't care about machine guns, you're gonna care about this case. So Congress passed many years ago now a definition, so law, okay, of what is the definition of a machine gun. And low resolution, it's if you fire more than one shot per function of the trigger, okay? Operative words being per function of the trigger. Function,
yes,
okay?
That is pull the trigger, gun goes bang, release the trigger, pull it again, then gun goes bang, not a machine gun.
Right, because it's the trigger has two separate functions there, right? The ATF, in their divine wisdom, decided to try
That was sarcasm.
Maybe. We're going to let the
okay.
viewers decide.
All right.
Okay. In their divine imperial wizardry wisdom, decided to move the goalposts for a myriad of different reasons, but they tried to reinterpret it. So you have to remember, the ATF is one of the 434 agencies and sub-agencies that exist in the nation. I will say it for the comment section. The ATF does not pass law. But, like it or not, what they are allowed to do is they're allowed to interpret law, apply interpretations of those laws, provided that those interpretations and any administrative codes and rulings are consistent and live within the statutory authority, both that they are interpreting as well as whatever authority has been delegated to them by Congress, the Attorney General, and so forth. Okay? So, what the heck does all that mean in English? The ATF can tell us and can apply what different acts of Congress says, but they cannot reinterpret and overstep the lines that Congress sets. So when the ATF goes out there and they take a statute that says a machine gun is more than one shot per function of the trigger, and they change it to machine gun is more than one shot per pull of the trigger, what they've done is they have changed something that looked at how the engine works to what is your foot on the gas pedal doing.
Right.
And those are two completely different things. And suddenly, you've got a lot of things and a lot of people who have been inadvertently committing felonies for decades because the ATF said, yeah, that's not a machine gun, like bump stocks. Oh, bump stock's not a machine gun because it's not firing more than one shot per function of the trigger. We're simply using a device to manipulate how fast the trigger is functioned, not more than one shot per function.
Right. We're just increasing the speed with which you are, in effect, pulling the trigger. And for those that don't know, a bump stock uses that inertia to move the firearm so that you're pulling the trigger much more quickly.
Right.
And again, whether you, like you said, whether you like a bump stock or don't like a bump stock or whatever, this is important in the fact that ATF was trying to redefine what is a machine gun outside the scope of congressional action of making law, and I'm glad it's going our way.
Yeah, if they were allowed to do this, again, it doesn't matter what we think about machine guns, but if ATF was allowed to get away with this, I mean, there's no telling where they're going next.
Yeah, we never know what definition they're going to lay out and say, this is now whatever.
Everything's on the menu at that point. So that was a very scary decision for me. While I did have a very bad feeling about Rahimi, I had a much more positive feeling and, a more positive feeling about Garland v. Cargill. I'm obviously glad to see that it turned out the way it did. It was a 6-3 decision. We will see where, of course, the downstream effects of all this go, because the ATF has been a very aggressive organism as far as using their rulemaking ability and their interpretation ability to go after gun companies, to go after individuals, to go after the Second Amendment. And it was nice to see the Supreme Court basically check that.
Yeah, absolutely. Whenever we can get a win in that area in the overall definition under the umbrella, that's solid. And Tom, I thought I heard you say something about the Court of Appeals, and are we back with AR-15 pistol braces again?
We are, because keep in mind, even though the rule was put on pause, thanks to our friends in Texas and the Fifth Circuit, that battle is very much still going on. In fact, that battle is going back into court in September for oral arguments. So just because we haven't been hearing about it, that doesn't mean nothing's been going on. And here we are again, this time in the Eighth Circuit. So we're talking about North Dakota, South Dakota, Missouri, Nebraska, those sorts of states. And this has a case called FRAC versus Garland. So FRAC is an acronym, FRAC, Firearms Regulatory Accountability Coalition Incorporated. Fantastic pro-2A group out there that sues to protect all of our rights. And they basically sued to say, look, this pistol brace thing, this is a gross overstep. Now, they lost at the district court when they're trying to get an injunction. Because remember, low resolution, the way that this works is someone challenges a law, they want to put an injunction on to stop the law from going into effect. Otherwise, these lawsuits that sometimes can last years, well, everybody can be getting rounded up and thrown in prison in the meantime. So
while we're fighting against an unjust law.
So we need to pause it from going through. And the district court, that's the federal trial court, said, nah, we're going to let it roll. Okay? So then we're up to the Eighth Circuit, and the Eighth Circuit said, no, we're not. we're also going to put a pause on this. Okay, now they left the details of the pause up. They sent that back down to the district court. But you're not going to believe what the ATF was arguing. Okay, so quick refresher, right? So we got the pistol brace in 2012. ATF said good to go. They said good to go multiple more times to multiple companies, you name it. Yes, this is good to go. Stabilizing braces, perfectly legal.
Millions of them out there.
Not a short barrel rifle. Good to, oh yeah. The Congressional Research Office said that there's like between 3 million to possibly 7 million and maybe even more of them out there. You know, and the ATF's blessing it, and all of a sudden it's just kidding. We're looking at felonies for all these people. Destroy, register, turn in, and by the way, many of you can't even register, even if you wanted to. So, you know, happy times, right? So the ATF, in order to, we're back to rulemaking land, okay? So they put out a notice of rulemaking, which is what you have to do before you can do the final rule. And this allows the public to comment and all that kind of stuff. So they published their initial rule, which talked about this worksheet that they invented, 4999. It sounds like some sort of like death order, you know, or something like that. Right, execute order 49, or worksheet 4999, right, exactly. So this was something that you needed a team of accountants to help you figure out, wait, I go through this scoring system, and if I get such and such a score, felony prison, got it, okay. So that's basically the way this worked. It got overwhelmingly negative responses across the board. No one asked for this at all. And the ATF, after 18 months, rather than releasing something different as another proposed rule of, you know what guys, 4999 didn't really work out, we get it, here's another shot at it, tell us what you think. They just said, hey, we're skipping to the final rule now. And the final rule, by the way, surprise, has nothing to do with what we told you it would be when we put you on kind of the notice of here's what we're looking to do. And there needs to be, in order to achieve accountability, transparency, and so forth, as well as to comply with the Administrative Procedures Act, the APA, there needs to be a relationship between the notice of rule and the final rule. So you need to be able to kind of follow along of like, okay, there's the notice rule, they're allowed to tweak it around the edges and make some changes, but they can't just chuck it and come out with a 2-part test with 6 clarifying questions, which is what they did. And it just left everybody in this place of, what? Where did this come from? Again, no one asked for it, but this time, again, comply by such and such a date or you're going to prison, right? This is what happened back in 2023. Here's the crazy argument, and I'm glad you're sitting down, okay? The ATF basically said, look, you're not allowed to sue to challenge this ruling because it's not a final ruling yet. It's not a final administrative decision that we've made.
They're just thinking about it.
Right. Yeah, you know, we're thinking about it. You know, I know we put some dates out there where you're going to go to prison potentially and all this other kind of stuff. But they argued, I mean, talk about the details of the details of the details. Yeah, you know, this isn't a final administrative agency decision. Again, low resolution here. And therefore, nah, you know, you do not have legal standing to challenge it. We get to keep rolling on. And the 8th Circuit Court of Appeals said, no, that's not the way this works at all. The ATF put out 2 slideshows where they said, yep, here's all examples of things that are felonies. They basically, by their own admission, said that 99% of the pistol braces, stabilizing braces out there are probably connected to situations that are now felonies. But they never showed us what the math is. So remember high school, that vague time, right? Yeah. So
a lot of bullying and stuff.
Yes, yeah.
I feel bad about doing that.
I knew something like that was coming. So, you know, the teacher always made you show your work. So when the ATF puts out this slideshow with all these different examples and pictures, you'd think that they would be saying, oh, example 1, we have this particular stabilizing brace attached to this particular firearm, and here's how we run our test so you can follow us. Nope, it's just a bunch of examples with conclusions. And they also say in this multiple times that people have to be registering on the National Firearms Act registry or else they're going to be facing action and so forth. So the court looked at all this stuff, among other things, and they said, this is absolutely a final decision. It's also a violation of the APA Act because you completely threw out your initial proposed rulemaking. You jettisoned it to do something completely different. You're only allowed to be looking at things. You can't be arbitrary and capricious. One of the definitions of arbitrary and capricious talks about, was this something that Congress was even considering, thinking about, setting thresholds for, all that kind of stuff when they passed the statute. So if you read the statute talking about what constitutes a short barrel rifle, because that's what the ATF is saying. These are all illegal short barrel rifles. They all need to be confiscated, destroyed, turned in, registered, you name it. And then if you look at what's their classification criteria to determine, oh, whether or not this is a short barrel rifle, things that Congress never even mentioned, like what's the rear surface area? How is it being marketed? What is the community doing with it? In other words, are people shouldering it or not? Nowhere in the congressional statutes or anything like that will you see anywhere, oh, well, you got to calculate what there's no mention of rear surface area. There's no mention of what is the community doing. There's no mention of, well, determine if this is an SBR. Look how it's marketed. They invented something that's completely beyond what Congress did, and the Eighth Circuit said no.
So in the interim, for the time being, your AR equipped with a pistol brace is currently legal, but that could change.
Yes, but not thanks to the Eighth Circuit.
Okay.
Despite the Frack v. Garland decision, what we know is the Eighth Circuit said, yes, there's going to be a preliminary injunction here. What we don't know is that only going to apply to Frack members? Is it only going to apply to other individuals? Does it only apply to specific brands? How narrow or wide is the district court going to do? Because the Eighth Circuit said, trial judge down in the district court, you absolutely need to be putting a preliminary injunction on this, but they left the details up to that court. So until we see that court rule, we don't know how narrow or wide they're going to go, which means for the time being, we're still counting our chickens on the Fifth Circuit.
Wow, it is amazing the way they pull all of this stuff together, and we're going to have a topic for another video coming up in the future. So. Still more gun laws out there. I know that the state of Maryland just had to reverse something that they did. Maryland's crazy law was that guns are illegal everywhere unless you post a sign that says, yes, guns are welcome in this building. And that has now been reversed and is going into effect soon, or went into effect very recently. Tell us a little bit about that.
Well, this is a very common tactic that we're seeing in anti-gun states, where the default setting historically has always been, look, a private property owner is allowed to post, I do not want guns here. And someone's private property rights generally trump things like free speech, Second Amendment, and so forth. So case in point, you have a right to free speech. You don't have a right to come into my kitchen with the bullhorn at 2 a.m. and start speeching.
and say this is protected First Amendment activity.
Exactly.
Yeah.
Exactly. So we have a protection of private property trumps. Same thing if you want to set up in your home I don't want people to be carrying firearms in here, you can do that. Okay? Just like I don't have to go in there.
Not that I would, but I don't want people getting.
But and I don't have to go in there. Right. Now it's obviously different when the government starts doing this, because maybe, well, for instance, my taxes pay for that bus stop, they pay for that subway, they pay for that library, they pay for that playground or whatever it is, right? That forest, that park. So there's a degree of, I'm not paying for your home, at least I don't think I am. So the result is that it hits very differently when the government's doing it for private places and calling it sensitive locations. Here what the government did is they basically set the default status for all private property to be illegal. There's exceptions to everything, low resolution, but it's illegal unless they post that it's accepted. And the question among many comes up of, is that an intrusion on the private property rights of all these people? To say no.
Is this forcing them to put up a sign that says guns are welcome?
Right.
Yeah.
Does the government have the right to tell people you're not allowed to carry guns here unless they let you? Because is that also not an intrusion on your private property rights? Right. Among many other issues.
Yeah, and it was very convoluted, and it is now gone. And in Maryland, they're not allowed to do that anymore. So
other states will try.
Oh yeah,
and have.
It's we could go on and on, but I don't think people want to watch a 45-minute video. Maybe just 32, like we've been doing now, or however long this has been going on. But as always, thanks for talking to us about the gun laws and keeping up to date on this. And we're going to watch what happens with the 8th Circuit. We'll see how that all goes, and the questions will never end. Thank you for helping us out, Tom.
Thanks, Kevin.
Did you know we have a secret gun giveaway going on right now you can enter for free? But it ends really soon. Just click the link in the description below to reveal which brand new gun you could win.